Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. Friends, video number 1756, date 25/5/2022. Right. The Supreme Court deprecates or comes down heavily on a judicial officer in Uttar Pradesh within the jurisdiction of Allahabad High Court for not releasing the accused despite the Supreme Court gave orders of bail and actually on the plea of the Section 3 and 4 of the Dowry Prohibition Act was not added. Very silly or simple issue. Already we heard the case of Nellore ADJ who did not care the Supreme Court stating that when the Supreme Court ordered that this man to be produced within 3 days before the court and the court has to consider about the bail plea. So when the person was produced after 6 days or so, the fourth, that is Nellore ADJ said they are not going to take up the matter because already the period given by the Supreme Court or sanctioned by the Supreme Court is over. Do you mean to say 3 days means 100% 3 days? That's why I told you in that case regarding Section 304B of the IPC. What it says, if just before death, if she is subjected to the so-called dowry harassment, it is called dowry death. So just before, what does it mean? Hours, days, years? So the matter has extended up to 7 years, even though she was tortured for dowry within 7 years of her marital life, it can come under 304B of the Indian Penal Code. So no doubt, the words of the Supreme Court can be taken in letter and spirit, but not too rigid, but not too technical grounds. This is what is stated in the case of Gopal Verma versus State of Uttar Pradesh in CRLMP number 819/2022 dated 19/5/2022 given by Justice Sanjay Kishan Kaul and M.M. Sundaresh. So while giving the rectified orders or while adding Section 3 and 4 of the Dowry Prohibition Act, the Supreme Court deprecated the act of the judicial officer for refusing to release the accused on bail. Actually, the case was registered on Section 304B IPC and also 498A IPC as well as Section 3 and 4 of the Dowry Prohibition Act. Of course, actually on December, I think in the month of December 2021, Honorable Supreme Court has given clear orders that considering the criminal appeal, assailing the accused, that is appellant, therefore the bail was granted in the meantime to the accused person. We grant bail to the accused on terms and conditions to the satisfaction of the court. So even though, of course, the plea of the appellant, that is accused person, is that the charge sheet was filed way back in 2021 and only one witness out of 64 cited witness has been examined. There is no actually point that the trial will be conducted very soon. Therefore, basing on the representation of the advocate, Honorable Supreme Court was pleased to order the release of the so-called appellant on bail, of course, to the satisfaction of the Honorable Court. But the order, please remember, the order said that the case was registered under Section 498A 304B IPC, that's all. They forgot to mention Section 3 and 4 of the DP Act. So now the Judicial, that is Additional District Magistrate, Additional District Judge, he said that since the section of law 3 and 4 of the DP Act was not added to this, it may be some other case, therefore I am not inclined to give bail and please file this is a refreshing petition. So once again they have filed a refreshing petition. Here the Supreme Court actually said, we don't appreciate the conduct of the judicial officer who did not release the appellant even in spite of the Supreme Court's bail order. No doubt, now we are allowing the addition of Section 3 and 4 of the Dowry Prohibition Act, but here definitely the accused has to be released on bail, but we are deprecating the attitude of the judicial officer at the particular place who has rejected the bail only on the so-called technical grounds, which should not have happened. So it is a slap on the face of the lower judiciary. They have to understand simply technical debate should not take place. Same thing happened in Nellore case also. In the another case, of course, at times such cases may happen. So whenever such cases come, I will definitely inform you. Here, the main point you have to know is whenever the Supreme Court asks a person to be released on bail, the court is bound to release him on bail. Maybe 1 day or 2 days later, a gap is there. So don't be under the technical condition that 2 days have passed. Or where the section of law 3 and 4, already main section 304B and 498A have been mentioned. What is the fun of what harm is going if 3 and 4 of the DP Act are not mentioned? So this is what they have to think over. So that broad knowledge, broad mindedness should be the judicial officer. If the judicial officer is narrow-minded, definitely Supreme Court may initiate action against them. That's all. So thank you very much.